It is my great pleasure to welcome Judge Fred Block, Cornell Law School class of '59, back to Myron Taylor Hall for his 60th reunion. Hello, Judge.
Hello, Liz.
Because Judge Block is the oldest living Cornell Law School graduate on the federal bench, we thought it fitting to sit down with the judge and learn more about his life since he graduated 60 years ago. But before we do, I wanted to share a few highlights of the judge's long and distinguished career. Judge Block was born in 1934 in Brooklyn, New York. He attended Indiana University, earning his undergraduate degree in 1956. He then came to Ithaca, graduating with his JD from Cornell Law in 1959. After graduation, Judge Block served as a law clerk on the New York Supreme Court Appellate Division for 2 years. For the next 33 years, he had a long and productive career in private practice on Long Island. In July 1994, President Clinton nominated him to serve as a district court judge in the Eastern District of New York, and he was confirmed that fall. Judge Block took senior status in the fall of 2005 and has served in that capacity ever since. He regularly sits by designation on the Ninth Circuit Court of Appeals. Judge Block has taught as an adjunct professor for many years at Touro Law School. During his 23 years on the bench, Judge Block has presided over a number of high-profile cases, including the trials of former Bear Stearns hedge fund managers Ralph Ciaffi and Matthew Tannen, Kenneth Supreme McGriff, Peter Gotti, Lemrick Nelson, and nightclub magnate Peter Gatian. Judge Block is also a very successful author. His first book, Disrobed, an inside look at the life and work of a federal trial judge, was praised by President Clinton, legal analyst Jeffrey Toobin, and television personality Judge Judy. He next turned his talents to the world of fiction and wrote Race to Judgment, a crime novel which was recently turned into a pilot for a new television series. His newest book is Crimes and Punishments, Entering the Mind of a Sentencing Judge. Prefaced by Erwin Chemerinsky, it takes a close look at the many factors judges weigh when sentencing criminal defendants. And finally, Judge Block is hard at work on another work of nonfiction. It will explore the evolution of street art, focusing on the history and litigation surrounding the Five Points mural space in Long Island City, Queens. We have so much to talk about, Judge, so let's start at the beginning. I understand that you had hoped to attend Cornell as an undergraduate, but that didn't quite work out. So can you tell us why a kid from Brooklyn wanted to go to Ithaca?
Well, first, Liz, it's nice to be here.
Oh, good.
And to celebrate my 60th reunion is something which takes a while to really absorb. Because I remember when I graduated in 1959, I and my wonderful classmates, one of whom is with me this weekend, Alan Smith, were talking to the lawyers who were celebrating their 50th anniversary, who graduated in 1909. And I remember to this day speaking to 2 or 3 of these people, and I realized fast forward to 2019 that I'd been able to reach back to 1909 as well as forward to 1959 or 1969. So the history and the richness of being at Cornell is something which really overwhelms me in a way. And it's very kind of you to give me the opportunity to talk about some of this today.
We're delighted to have you, Judge.
How did I come to Cornell?
And I want to hear the story about before you went to Cornell, because I read your book, and in your book you tell us that you wanted to go to Cornell undergraduate, and I wanted to know what sparked your interest in Cornell in the very first place.
Well, it was a revenge motive. I was actually rejected by Cornell for undergraduate school.
Right.
And it was the first time I had to live with the rejection. It was really depressing. But I didn't score so well on the SATs, I guess, in those days. And I didn't realize that, I have an eye condition and I have difficulty in reading. Mm-hmm. Maybe I was dyslexic a little bit, stuff like that. I was 4F in the Army because of my eyes. And I didn't score well on these aptitude tests. So I wound up going to Indiana University, not because I was so smart or I had, grand designs about anything in those early days, but my camp counselor went to Indiana and they had a good basketball team. game. So it wasn't a very high-minded choice. It turned out to be really a blessing in disguise, because this kid from Brooklyn wound up spending 4 eventful years in Bloomington, Indiana, and being exposed to a different culture and meeting people who I never would have met before. I'm grateful that I had the opportunity to have that Midwest experience. But I had to get revenge on Cornell. So I applied for law school and I got accepted. So, here we are 60 years later.
And we're fortunate that you did. So I understand that on your first day of law school, your constitutional law professor, Gray Thoron, who was also the newly appointed dean of the law school, called on you. And can you tell us about how that first hot seat went for you?
Well, it's okay. I'm about to be embarrassed. It's all written about in my book, and I'm glad I wrote about it and my experiences at Cornell. But, you can appreciate, I'm sure all 1L, students have that first day experience when they come to constitutional law and they're sitting there and hear Dean Thoron, new constitutional law teacher, wanted to ask some questions. So he said, now we're talking about Marbury versus Madison. Where did the lawyers hang their coats? Mr. Block. I don't know why he picked me out. So I blurted out in the coat room. And everybody laughed. And then the dean said, well, the paper chase, sometimes people get into Cornell who don't belong here, but, we weed them out after a year, and there's little likelihood that you'll see Mr. Block here next year at this particular time. So I became a pariah. And I would be walking down the street, and my good friend Alan Smith, would see the dean come, and he stayed with me, but most of my classmates would cross the street. They didn't want to be seen with me, who was, this terrible, terrible student at Cornell. At the end of the 3rd year, the good dean called me up and invited me to come to see the Harvard-Cornell football game. He was a Harvard guy, and he apologized. He said, Mr. Block, sometimes I get it wrong, and I wanted you to come here today to apologize because I just, were all wrong about you, and I think it's great that you stayed the course, that you didn't shoot yourself, that you didn't resign from Cornell, and that we're here to watch Harvard beat Cornell, because his loyalty was still with Harvard. And we sustained a relationship after that. He became a member of the New York State Ethics Committee. He would invite me back to Cornell because he used me as a representative of a graduate who had a small firm practice. In fact, it was me. And he would invite me to meet with his ethics class, and then the next week he would have Milton Gould, who was a big shot New York City lawyer, and he used us to show that Cornell law graduates can do a lot of different things. They don't all have to be with a major law firm. They can be solo practitioners in Suffolk County. And fast forward, when I became a federal court judge, I came from Suffolk County, not from a big firm. So I think that that's in race to judgment. And I get a lot of positive feedback, which I enjoy, from young law students who feel that they don't have to necessarily all graduate from Harvard. They don't all have to be number one from Cornell, and they don't have to be with a big law firm, and they can still maybe wind up as a federal court judge. So I feel pretty good about that background that I'm able to share with you and the folks today.
Yeah, and I think that's an important message, right?
Very important. And I would talk about that when the dean invited me back to talk to his class on professional practice and ethics, that there are many different ways in which you can enjoy the practice of law. And the important thing is to be passionate about what you do and not feel that there's just one road that leads to Rome, which of course is not the case. So I was representative of that, and I write about that in my books to some extent, because people should realize that, you don't have to necessarily be number one in your class or be at Harvard. You have to do pretty good. I mean, I did well enough to get here, but just enjoy yourself and don't feel that you have to just be with a large corporate law firm and do all the work that they do. I'm not that type of guy. I'm a sort of a small firm type of guy.
That's good advice. You've said that your favorite professor at Cornell was Professor Joseph Sneed, who taught you contracts. Can you tell us about him?
Yeah, so we had a very profound, wonderful professor of contracts. And contracts, I don't know what it's like now, but this was a whole year course. Is it still the same way? I don't know. So the exam you take is going to be in May, And you don't know whether you're fish or fowl. I mean, you're a new student, you're concerned, you're worried, you don't know what you're going to be, where you're going to wind up in the class. So it was George Jarvis Thompson, and he was the editor on Williston. If you look at Williston's great treatise on contract, you'll see George Jarvis Thompson on that book as well. And I didn't understand a thing that he said about contract law.
Wait, so this was the first professor you had in contract?
And unfortunately, he passed away climbing the steps of Statler Hall.
Really?
In December. And he was replaced by Joseph Sneed, who came from Texas. And Dean Thor knew him and he brought him here. And he was quite a guy. He was somewhat disabled. He walked like this, you know, and he had a hump on his back. He spoke with a southern drawl. But I understood contracts when he spoke to us. And at the end of the year in May, lo and behold, I got an A- for that 5-credit course. Years later, Joe Sneed became the dean of Duke Law School. After that, he was appointed to the Ninth Circuit Court of Appeals. Distinguished jurist, highly regarded legal scholar. And as things would happen, one day I got assigned to sit as a visiting judge on the Ninth Circuit Court of Appeals in the San Francisco beautiful federal courthouse. Walking down the hall, I passed the office of Judge Joseph Sneed, and I stopped by. And I told him, you know, I don't know whether you remember me. He pretended that he did. I said, but I was in your contract class. And if you didn't give me an A-, you know, I wouldn't be here today. You saved my life. And so here I was sitting as a Circuit Court of Appeals judge in the Ninth Circuit, Judge Sneed's courthouse. So, you know, it just shows you that you just never know what's going to happen. But you know, just be open-minded and let the things just come your way. And that was just such a compelling story. I visited him again. His daughter was Carly Fiorina, who people know was counsel to Hewlett Packard. She became a politically active person. He had a son who was a negligence lawyer down in Austin, Texas. And every time I came to California, I visited him. He passed away a few years later. But what a connection. And I would only call him Professor Sneed. I could not say Judge Sneed. And, you know, we would sit in his chambers. He was an opera buff. We would listen to opera together. It was just such a gratifying experience to see that linkage between me as a student of his. And he was really happy because I think from a professor's perspective, to see that your students become successful, that they're happy with their career choices, that they're grateful to Cornell, the wonderful education, and they become federal court judges and sit on the Circuit Court of Appeals. And he said that he was so gratified to see that and that he made a big difference in my life. There's no question about it.
That is a great story.
Yeah.
So your first job out of law school, before you became a solo practitioner, was with the New York State Supreme Court Appellate Division in Albany. And I wanted you to talk about a little bit what that position was like and you know, how it contributed to your development as an attorney and later as a judge.
Well, you know, I'm a great believer, as you know, in the opportunity that graduates have to clerk for a year or two on any court, actually, just to be involved in getting a feel for how the process works behind the scenes, so to speak. I came about this, you know, just circumstantially because I was between the Vietnam and the Korean War. A lot of people forget there was something called the Korean War here. We've had so many wars, right? And I was going to go into the judge. I had 2 years of ROTC in Indiana. I was going to take my last 2 years here, but I didn't pass the physical because they have higher qualifications for officership than they do for privates, believe it or not. And even though I wanted to be a lawyer in the Judge Ad Corps, I didn't pass the physical for that. But I was still qualified to be a private, and I was not happy about that. Eventually, I was 4F from that because of my eye condition. But I had graduated. I did not really apply for any positions at all because I thought I was going to go into the Army. When that did not happen, I called up. I spoke to Dean Thor, and I said, you have a job for me? And he said, there's a clerkship opened up in the 3rd Department. And I said I would do it. So I came to Albany that way. The clerkship was wonderful. I stayed there for the better part of 2 years. We wrote a lot of, drafts of opinions for the Third Circuit. They did a lot of work from the cases that came in Albany, the Public Service Commission, a lot of workers' compensation. All of the appeals, I didn't know that, in workers' compensation came to the Third Department. I wasn't terribly happy about that, but the experience with interacting with the judges and being on the court was just invaluable. I'm a big fan, as you know, of having clerks come in. I so much enjoy having the young clerks that you recommend and send to me and to the other Cornell judges. And it just makes you feel very special to be connected to the next generation of lawyers.
Excellent. So in 1961, you embarked on a career in private practice. And fairly soon thereafter, 6 years later, you found yourself arguing before the United States Supreme Court. So I would love for you to tell us that story today.
So everything's in my first book, but it's great to be able to talk about it as well. So I went to Suffolk County afterwards, and I was just...
After your clerkship, you went to Suffolk County?
Yeah, and I met some people in Albany, and they said Suffolk County was a place that was going to be very, very much an important county. It was an emerging county, part of the Long Island world, and so I went there. And I got a job with a law firm. I stayed there 9 months, and I opened up my own practice. Don't ask me why. So I wanted to stay involved in the law. I was handling collection cases, whatever would come through the door. I had 18B assignments as a criminal county legal cases. And I wound up, there's a long story here, but basically what happened is that the first complaint I drafted was a case called Bianchi versus Board of Supervisors. And I happened to be living next to somebody who was from Suffolk County who explained the history of Suffolk County, that they had 10 towns. And on the County Board of Supervisors, each town was represented. They each had one vote. But the 5 populated towns from the western part of Suffolk County had 90% of the population. The 5 eastern towns like Southampton, Shelter Island, West Hampton, they had 10% of the population at equal votes. Baker v. Carr was just decided by the United States Supreme Court. It's one of the Burger Court's watershed, not the Burger Court, the Warren Court's watershed cases. Brown v. Board of Education, and Baker v. Carr. Baker v. Carr was the decision that opened up the concept of reapportionment, equal representation, as a justiciable issue. Before then, it was considered to be a political issue, not for adjudication in the courts. Since then, what emerged was the concept of one person, one vote. Equal representation from equal population district is the order of the day. We read today about the fights that go on with gerrymandering and with everything that's happening before the Supreme Court today, whether or not the concept of one person, one vote is being properly applied to this day. So anyway, we thought that that would be a perfect test case to see whether or not the concept of one person, one vote, in those days it was called one man, one vote, how politically incorrect, should be extended to all elective levels of government. And I thought that this would keep me sane, give me something to do of some substance in addition to just trying to make a living as a new lawyer. So that was Bianchi versus Board of Supervisors. Little did I know that when I prepared that complaint, that 4 years later I'd be arguing in the United States Supreme Court. And it was the only case I argued in the Supreme Court, and I figured that I would not be there again. But what an experience, only because I was open-minded and willing to really take my Cornell law education and do something with it while I was trying to build up a bread and butter type of practice as just a struggling young lawyer. So that came in handy years later. When we argued the case in the Supreme Court, we did not have a fee awards statute. 1988 was not enacted until 1968, I think. This was the year before, 1967, when this happened. So I didn't get a penny on that case. But it sort of came in handy years later when I was being considered for the federal court clerkship to be able to tell Senator Moynihan about that.
Well, it paid its dividends.
Yeah, and when I look back at the things that got me here as a federal court judge, none of the things that I did I made a penny on. The Clayton case, the volunteer work, this type of cause, that type of cause. And it dawned on me that if you really are open, and are willing to lend yourself to things that you feel passionate about, it's a quality of life that you really want to embrace. And I think that I'd make a penny on any of the things that got me into this position where I'm at today. Yeah, it's an interesting dynamic.
It is. And I'd like to hear more about the nomination process and the confirmation process, what that was like for you.
So, I'm going to recommend my first book, This Rope,
All right.
because it's all in there.
All right, so let's just take that book out. Let's take a look at it. So this is your
I
first
wrote this
book.
several years ago when I was 78, and it's
A mere
really,
78.
Yeah. And I started to write it. And I did it because I thought it's important for federal judges, all judges, to reach out to the public and write a user-friendly book to explain things. How do you become a federal court judge? I'm told, that 10% of the public thinks that Judge Judy is the United States Supreme Court Justice. So I think there's a real need to really educate the public. So the first part of this tells you what we're talking about right now, how I came from Cornell to being a solo practitioner to becoming a United States federal court judge. The second part talks about how we run the courtroom and things about the ABCs of the management of the job. The last part talks about the so-called high-profile cases that we have, discrimination, death penalty cases, and a lot of foreign affairs and stuff like that. So this book really, I'm glad I wrote it, but if anybody's curious, they'll find out about everything that I've done to get to be here today. So, that was the first thing I did.
So in this book you talk, but I'd like you to talk about it in case people don't have a chance to read your book or read every page of it. Tell us about the nomination and confirmation process. How was that?
The way it works basically is that you have to be recommended to the White House, and most of the times it's a senatorial recommendation. And in New York at that particular time, we had Senator Moynihan, we had Senator Javits, there was a Democrat, there was a Republican. And the process is that whoever's in the White House, they worked that out amongst themselves. They would get 3 out of 4 recommendations to the White House. So if a Republican was in the White House, then Javits would recommend 3 out of 4 to the bench, and Moynihan would recommend 1. Conversely, when Clinton became president, it changed. At that time, Senator D'Amato was Republican senator. Moynihan was still Democratic senator. And I was active in Suffolk County in the Bar Association. I was president of the Suffolk County Bar Association at that time. And I interviewed with his merit selection committee. And Moynihan was a very unique person. He was highly regarded, and he really believed in merit selection. The first time I interviewed, I was not tapped for the position, but eventually, some years later, I went back again, and I was recommended by his committee, and I never met him. And people, ask me, who was your rabbi? And I said, I never had a rabbi. Senator Daniel Patrick Moynihan really believed in what he believed was merit selection. And somehow this background coming from Suffolk County, being involved in the matters I had out there, rang the bell. And I was, nominated, recommended to the White House by Moynihan in those days. So it was quite a story. Yeah.
And what was the confirmation process like? What was that? Did you have? What was the? Was there was a hearing?
So, most people don't realize that we are Article 3 judges in the Constitution, and the process is the same whether it's the Supreme Court, Circuit Court of Appeals, or District Court judge. You have to be nominated by the President and confirmed by the Senate. And most district court judges are not controversial. Sometimes they are. But I had to appear before the Senate Judiciary Committee. I had to be screened by the FBI. There's a whole process that you go through. And we got recommended by the Senate Judiciary Committee and nominated. At that time, it was not terribly controversial. And Clinton just became president. And Moynihan's recommendations were respected because he was highly regarded. He was chairman of the Senate Finance Committee, and it was unlikely that his recommendation would be rejected. But it's still really something because you're there, You're in the Judiciary room. You're being questioned by the senator. I think it was Howard Heflin from Alabama who was the chair at that time. And, then a lot of things can happen. This whole process can become very political. It wasn't then, but it sure is now. And there are a lot of people that feel very strongly about that. And I think that there's much we can discuss about that. It would take much longer than what we're doing today to talk about the politicization of the judiciary, which is something which we feel strongly about because we believe in the independence of the judiciary. We believe in the institution. And I think that by and large, most federal court judges are guardians of the institution, the third branch of government. It sounds kind of Pollyannish, but it's something we really strongly believe in. I think the Supreme Court, regardless of who is going to be in the Supreme Court, will protect the institution. I think Chief Justice Roberts feels strongly about that, and I have a lot of confidence in that as well. When I sit on the Ninth Circuit or when I talk to my colleagues in Brooklyn, we don't really ask ourselves much about what your political philosophy is. We're focused on trying to take our responsibility and doing the best we can with the law and trying to get it right. But nonetheless, what creeps out through the media is that these are political people, political appointments. It starts that way, yes, but these are highly qualified people. The federal judiciary, wherever I go, whether it's Wyoming, Montana, Florida, the people on the bench who have gone through the process, because you have to be screened by this committee, by that committee, by the Justice Department. And even though there may be political hooks out there, these people by and large are competent. Even today, where we have this divisiveness in the country, the people who, the current President Trump, who has nominated people to my court, they're all highly qualified. We respect that. Some of them are Federalist members, some of them are from the liberal. You don't want all of one kind, but what you want is the common denominator is competency. And I think that the federal court, if you speak to people by and large, which of the three branches of government do they have the most respect for? I think 9 out of 10 would say the third branch of government, because it's still perceived to be not corrupt. It's still highly regarded. When people come into my courtroom, they don't ask you whether you're a liberal or a Democrat. When I write decisions, I'm not conscious of whether I'm a liberal or a conservative. I don't know what I am. I like to feel that I'm just trying to come to the right decision. And the curious thing about it is that, in my books, I have depends on, what case you want to talk about. I'm either a liberal judge or a conservative judge. I've had the Heritage Society praise some of my decisions. I've had the liberal papers praise some of my decisions. I don't know what I am, and I don't want to know what I am. I really, truly believe that we should try to just get it right and not let your mind be influenced by labels, which I abhor. It's just counterproductive. So you can see I'm getting a little bit passionate about it because I really feel strongly about this, and I'm glad you asked me that question. So you gave me an opportunity to make a big speech.
Good. That's exactly what I wanted to hear. I wanted to know, you've been on the bench for quite some time now. Can you remember back to what it was like to be your first day as a judge?
It's a lot different than today. So when you first get on the bench, you're really concerned about passing the bad smell test, as they say.
What do you mean by that?
Well, everyone is looking at you. Who is this person? Especially if you didn't come from a big law firm, or you were not a U.S. attorney or professor from Brooklyn or NYU.
So you're just some guy.
And I snuck in overnight from Suffolk County. Who is this guy, right? So you're very concerned about that. And so I spent the first week doing nothing but reading the rules of evidence over and over and over again, because people are sizing you up and you're very concerned about it. Now, what's really important is when it comes to sentencing, because district court judges' primary responsibility is to deal with sentencing. And my third book that just came out this week is about that.
We'll
so
get that
I want
one
to put
out.
in a plug for that.
We'll jump to the third book. Here you go.
Yeah. So Crimes and Punishments, Entering the Mind of a Sentencing Judge. I talk about what went on in my mind when I sentenced people to jail. And I take 5 or 6, subjects: mandatory minimums, acquitted conduct, collateral consequences, high-profile public official cases, the mafia, and I go through the sentencing process and what goes on in my mind when I have to really draw that number. And I've sentenced over 1,000 people over 24 years now. So I like this book a lot because I think it's interesting reading, and I think it's important for people to get a sense of the humanity that goes into the sentencing factor. So when you first get on the bench as a new judge, your main concern as a district court judge is how are you going to sentence people charged with crime, who have pled guilty, who have been convicted. So we go to school. It's called Baby Judges School. And they educate you about the sentencing guidelines and about how you go about sentencing, right? And we had these mandatory guidelines in those days. Now it's more discretion. Since Booker was decided, we have a lot of discretion. And you can talk to 10 judges about one case. They'll all sentence that person differently. So what goes on in the sentencing judge's mind is what this book is all about. And I think it's going to be something that's going to be worth reading by law students or anybody, actually. So when you first start to sentence somebody and you're a new judge, you're going to be a little bit more cautious. You don't want to get reversed. You sort of don't want to be controversial. You don't have that type of security yet. You know, that experience will bring eventually. So you play it safe.
Right.
So I look back at the sentences that I imposed in my early career, and I probably would be sentencing less today than I did in those days.
So playing it safe was a tougher sentence, was a longer sentence.
So, you know, when I talk a little bit in the book about the fact you don't want to have your client be sentenced by a very old judge. And I tell the story of Judge Bartels, who was on the bench when I got on there. He was 99, and he was sentencing people when he was 96. And apparently this is a true story, and it goes on, and I talk about that in the book, that some lawyer was saying, Judge, if you sentence my client to the mandatory term of 20 years, it's not a mandatory, to the permissible term of 20 years, the maximum sentence, you'd be sentencing a man to life because he's so old. Right. And the judge said, well, how old is he? And he said, well, he's 70 years old. So it seems like a young man to me. And he gave him 20 years. So there's a little bit of risk about, you know, being sentenced by an old judge, and there's a risk about being sentenced by a young judge because they're going to play it safer. So the sentences that a new judge is going to render will invariably be different than that judge will render 5 or 10 years later. That's been my experience. And right now,
and what changes? What happens in the 5 or 10 year period?
Well,
how does that happen?
You're being exposed to a wide range of people who've had, you know, criminal issues in their lives. You develop a little more confidence with yourself. You're feeling a little bit more secure with yourself. You're able to exercise more discretion when you think it's indicated. And I think that it's a mindset that's different with the passage of time, where you're not worried as much about whether you're going to get reversed, whether the papers are going to say something bad about you. And because of that, you become a little bit more secure and confident in yourself. Okay. And with that, I think, comes along better sentencing decisions that you make.
Okay, all right. So when you think back, I know you've seen so many cases, civil and criminal. You've seen hundreds and hundreds and hundreds of cases in your career. What are some of the most memorable for you?
So obviously they're all in my books, right? But there was one that I feel particularly fond of, and it's the Nesmith case. Okay. And this was the typical situation. A young woman went down to Jamaica to visit her parents, came back, and was caught with some drugs in her suitcase at the airport. Okay. And she went to trial. Okay. And she was appropriately convicted because she was caught with drugs, and terrible thing. She lived in Connecticut, and she wanted to be a school teacher, and she had a perfect record. She was doing all sorts of good charitable things. She was doing well in school. This was a bad hair day in her life, and she was punished by being convicted of a felony. And then I had to sentence her. And at that time, I read a book which made an impression on me. It was Alexander's book, The New Jim Crow. And she wrote this polemic about how they have these collateral consequences that really keep people incarcerated even after they are out of jail. Why? You can't vote. You can't do this. You can't get these benefits. You can't get teaching certificates. There's a whole range of collateral consequences.
Sure.
The ABA did a study on it. And I read that and I said, wow, I never realized that there were over 1,000 collateral consequences that attach to a person after they serve their time in jail.
That's a lot. That's a great
about 170 on the federal level, and each state maybe about 1,000. And I said, wow, I never realized that after many years on the bench. I didn't put her in jail. And that became somewhat controversial because I wrote about the fact that the collateral consequences that she would be facing should be a sentencing factor and should be considered by a sentencing judge. And I called attention to this whole issue of collateral consequences that I felt had to be addressed because Congress just establishes these consequences, but who's going to complain about it? Nobody cares about these people by and large. So that's something I feel very good about because it got a lot of attention nationally. I think there's been some reforms that are happening now. We have a new sentencing set of laws that Congress passed. That was one of the bipartisan major pieces of legislation that came out of this administration. Sentencing reform is sorely needed. I think both the conservatives and the liberals both recognize that, so we're making some progress in that respect. So I use that as a test case. Now, I got criticized by some of the local papers about letting a person, who was convicted of drugs, not incarcerating that person. But I also got praised by a lot of magazines, including the conservative papers, that thought that these collateral consequences are something that needs to be addressed and attended to. So that decision crossed so-called political lines, and I feel pretty good about the fact that I wrote that. I've been asked to speak throughout the country about it, and I just feel very good that I use my office to speak out about an issue that I stumbled upon, I felt strongly about, and so I think that probably is the one that I feel best about.
So we've talked a little bit about your books, and in the introduction I talked that right now you have 3 written. So your first book was Disrobed, right, which was the inside look at the life and work of a federal.
There's a lot about Cornell on that
child. Yes, I know. Yeah. Tell me, so you became an author at age 78.
78.
Right. What was the genesis for you? What got you wanting to write that first book?
Well, I couldn't have written it early on because this is sort of the summation, memoir of things that preceded. Right. But I remember my father, who passed away at the age of 61. When he was 60, my brother Leonard, who happily is still amongst the living, adopted Pat, his child. And my father was, a very conservative person. He would even sit at home with a shirt and tie on after he came from the office. And we always chided him. He had no creative instincts at all, so we thought. But he liked real estate, and he would sort of doodle at night when he couldn't sleep and put little furniture boxes in rooms and things of that nature. So Leonard got the bright idea to give him a Humpty Dumpty paint-by-the-number set for his new granddaughter. And my father was able to follow those dots, and he did a very, very good job. It was the best Humpty Dumpty, you can ever find, right? The next year, when he was 61, we gave him a set of oils. And since he liked real estate, we gave him a copy of a Utrillo Parisian Street Scene.
Okay.
He didn't know how to mix oils. He knew nothing about art, and he was this person who had no supposed talents at all of a creative nature. 3 months later, you could not tell which was the Utrillo and which was my father's painting.
Really?
And he painted 6 or 7 more, then he passed away. So I thought about that, and I realized that all of us have untapped resources that we're probably not even aware of, whether it's poetry, whether it's music, whether it's art, whatever, and to be aware of the fact that you may be living a little bit more of a one-dimensional life, going to the office every day, working 20 hours a day, making a lot of money, chasing the rabbits, and you may be missing out on the creative part that you're not even aware of, like my father was. So I sat down at the age of 78. I said, look, if my father can paint that Utrillo at the age of 60, 61, let me put some thoughts down about things that really I've been thinking about for the last 20 years or so. And I started to write, and ergo the book. So that's what triggered this part of my life. So at this stage of my life, celebrating my 60th anniversary at Cornell, where I'm the oldest Cornell judge. I can't believe that.
Yes, you are.
Hoping that I'll stay in first place for a long time.
I'm sure you will.
I have this new life, so to speak. I'm still on the bench. I still sit on the Circuit Court of Appeals, and people ask me how I do. But when you're motivated, when you have some sort of an engine within you, you just do it. I always used to say, if you have a job to do, give it to a busy person, not a non-busy person. You'll get it done. They're more efficient. They're more turned on. They're more capable of performing. And I do this. This is just, my life. This is something I enjoy doing. And out of this came, I'm writing them faster than people could read them now at the age of 85.
You are. Yeah. Well, and your second book is so different than your first, right? So your second book which is the one we have not yet pulled out of the stack, Race to Judgment, is a work of fiction. So what made you, what made you change gears then?
So I call it reality fiction. So after I wrote this book, I got a phone call one day from Michael Ponce, who is a colleague of mine who I'd never met, on the district court in Massachusetts.
Okay.
And he just came out with a book called The Hanging Judge, which got a lot of play. It became a Times bestseller. And so he said, Fred, I read this robe. Why don't you write a fiction book? I said, Michael, I never went to school. I have no capacity to write fiction. You'll be surprised. Yeah. And, and also the cases we've had, you have ideas, these high-profile cases, these interesting cases, Peter Gotti, this or that. There's a rich material there that you can draw from. Yeah. So I thought about it, and I had 5 cases that year which really made an impression on me. And I thought that they could make the basis of an interesting mystery. So I call it reality fiction, and the story is based upon cases that actually I tried. One person who was wrongfully convicted, who was in jail for 16 years. Wow. That spawned, the part of the book where we talk about this guy championing the cause of wrongful convictions, and it really happened in Brooklyn. I can't go on and on to talk to you about it all today, but I got the bug from Michael Ponce, so I started to write this book. And I didn't realize that after I wrote it, that I would get a call out of the clear blue from a person who said she was a producer from London named Michelle Wright. She said she produced, and she did, 50 movies. And she said she read this book, and I fly to New York and talk to you about something. And she says, I think this would make a great series for television. And wow, can we have maybe 4 or 5 months to see what we can do with it? And I said, whatever, why not? A couple of months later, I got a call from her and somebody else from LA. They have somebody who is a screenwriter who read the book, and he thinks this could make a great TV series. And this person is a real person. John J. McLaughlin is now in the process of writing the pilot for this story. And taking and developing the characters, and we hope this is going to be a successor to Law and Order. Maybe the Game of Thrones, who knows, right? Who's John J. McLaughlin? He is the person who got all these awards for writing a movie that most people have heard about called The Black Swan with Natalie Portman. And he wrote that movie, and he got all the awards for doing it. He wrote Hitchcock. Wow. So lo and behold, he's coming to Greece with me this summer. We're hanging out with him a little bit. And he's in the process of writing what hopefully will be maybe the next Game of Thrones.
That'd be
I
fantastic.
don't think so, but, we'll stay tuned.
You never know.
So, I always talk about the fact that, and I sort of now, because I'm old now, so I have these words of wisdom to share with younger people, supposedly, I use the analogy of a pond. If you throw a stone in the middle of the pond, you have control over that. The book could be the stone, right? And there's going to be ripples. And you don't know how many, you don't know how wide they're going to be, you don't know where they're going to lead, but for sure there will be ripples because you somehow had it within you to toss that stone in the middle of the pond. So I'm a great stone thrower now. And I tell lawyers especially, take chances, take risks, because unless you do, you're not going to have any ripples, and it's just, you'll never know what's going to happen. But you know for sure that if you don't toss that stone, you're not going to get any ripples in life. So I use that as an analogy, and I am a great believer. I never in a million years thought I'd be here today when I was in law school. I never in a million years thought I'd be holding this book up and talking about possibly having a TV series or writing about these other issues that, press me. So I'm a great believer in reaching out, throwing stones in the water, seeing where they go, taking advantage of it. And there's no question but that it's pretty good when you age, to be able to do these things, because I can't trust my law clerks to tell me when it's time for me to hang up the gavel, as the saying goes. They're not going to say, Judge, I think you should quit. But we're aging, and especially in the federal court where there's no age limitations, it could be an issue. And I'm sensitive to that. And I want to be able to quit when it's appropriate to do so if I feel I no longer can be an effective federal court judge. But I figure as long as I can write books, I'm not senile yet.
You're probably okay.
Yeah, so, we're going to keep going until I write a lousy book.
Well, so to segue, I'm sure your next book will not be lousy. Tell us a little bit about what you're working on now.
So this got me going because I had this year a very interesting case, something entirely different. Now, the federal judiciary has total jurisdiction. We get every type of thing, criminal, civil, you name it. The only thing we can't do, because of the 10th Amendment, separation of church and state, you learned that in Constitutional 1, right? We don't handle domestic relations. That's strictly for the states, right? But we have otherwise this wide sweep. And I think that, what was I going to say again?
We were talking about your next book.
Maybe it's time for me to retire.
No.
So,
No.
I'm talking about that. So I had this case involving graffiti artists who were painting on the walls of a big building in Queens. And it became known as the Mecca of graffiti art, aerosol art. And it was a magnificent building with all of these prominent aerosol artists painting on the walls of 5 Points.
So 5 Points is a place.
Yeah, and you can Google it. You'll just see 5 Points, and you'll read about all of that. So the question was whether or not the owner of the building had the right to tear down the building. He wanted to replace it with luxury condos. He had bought the property 40 years ago when it was really in a crime-ridden neighborhood. It evolved over the years, but at the time that he wanted to tear the property down, this building became internationally known as the Mecca of the repository of great aerosol art. We had this lawsuit. And these 21 highly gifted aerosol artists wanted to enjoin the building from being torn down. I had to decide that. I didn't grant a preliminary injunction. The builder tore the building down. The case went forward afterwards, and a jury and myself determined that he acted inappropriately. I awarded $6.7 million to the artist. It's on appeal right now, and this got a lot of international play, the idea of street art, expressing yourself on the walls of buildings, the streets of New York, the Berlin Wall down in Miami. There's a big wall down there. I think it's called Wentworth. And even in the new Freedom Center. They're commissioning people to paint on the walls of the Freedom Center. New hotels have these artists now decorating the halls with what used to be known as graffiti, but now has evolved into street art. It started with Jean-Michel Basquiat in the 70s. Andy Warhol had something to do with that. And now with the lawsuit that happened here, these 21 artists who brought this lawsuit wanted to use this as the way of getting themselves identified with making street art, aerosol art, outside art, a real respectable artistic form of expression, which I think it is. So whenever you travel around, you'll see examples of this. A lot of it is not so good, but these people have painted magnificent paintings on the walls of 5 Points, which is no longer in existence. Gave me the idea to write the next book about that. The case is on appeal. I'm not going to do anything in terms of publishing anything, of course, until the case is decided, because you really, as a judge, can't really write or comment about cases that are still pending. It possibly could be remanded. It may go to the Supreme Court. It's going to be argued in the Second Circuit the last week of August in all probabilities. They want to get me reversed in the worst way because I gave this enormous award to the artists. I could spend a whole day talking about it, but it gave me the idea that this is interesting material to write because it joins the law together with the artistic world, the creative world, and the law and the rights of builders, property rights, in tension with the rights of the virtual visual artists, so to speak. And I thought all of that created interesting dynamics, gave me the idea for hopefully what will be the next book, which I think is going to be pretty interesting reading. It'll be like a combination art book plus the judge telling the story of 5 points. Let's see whether it happens. I can't talk too much about it because the case is still technically pending.
Of course, of course.
Yeah.
So one of the things you said earlier is that you you've written books and you like to have law clerks and because you want to sort of share what you have learned over time, of course. And if you were able to travel back in time to speak to yourself when you were an undergraduate or you were a first-year law student, what advice would you give your younger self?
So, I tell people that you have to look at yourself in the mirror 2 times in your life. One, when you're like starting law school, what should I do? What kind of law do I want to practice? Do I want to be a litigator, which is only 5% of lawyers? Do I want to be a transactional lawyer? Do I want to handle trusts in the states, immigration law? What do I want to do? Where do I want to seek employment? So you have to take a long look at yourself. Well, then you ultimately come to a resolution. Hopefully you're going to find something that's going to be stimulating, that'll give you an enriched life, and then you come to the end, 60s, 70s. Now we're living longer, obviously. We're Exhibit A right here, right? What do I do now? We have a culture, I think, in the United States when in your mid-60s, you're no longer going to be the managing partner of a major law firm. You're sort of sent out to pasture. Lawyers now in their 70s, they sort of are aged out. They're not as vital as they are. They still want to be involved. They still want to be a contributor to society, but we don't really value the older judges here as much as maybe some other countries like Greece, perhaps, places throughout Europe, China, perhaps. So it's a real issue. And then I tell the young lawyers that you got to look at yourself the second time in the mirror when you're 60, maybe 70. Wow, all of a sudden we're living longer. What do I want to do now? And that's the second time you have to say, well, what now? I mean, I've had a career, I've worked. What is it that I can do? Can I write? Can I have this hobby? Can I have that hobby? Can I volunteer here? Can I work on death penalty cases? So I think that, there are 2 stages now, and that's really the beginning stage. And at the latter part of the stage, after you have worked hard to support your family and built up the reputation that you've built up, you have to look at yourself in the mirror a second time. So that's the type of thing I think about. It's just not one-dimensional, that we should really think about variety in our lives, not be caught up necessarily in just, 20 hours a day working for, the law without having hobbies or other interests. Try to keep a balanced life. Go to museums once in a while, go to the theater once in a while, read Judge Block's books once in a while, and try to be balanced if you can, and resist, the draw of money that's going to suck you in to be a 24-hour, 7-day-a-week type of lawyer doing just depositions. We pay a price, because I'm from a small firm mentality, that we get sucked into sometimes, and we know about it, the lure of money with the big firms. But you pay a terrible price for it in terms of your personal life. You're a slave for 6 or 7 years. Maybe you'll make partner. Most of the times you won't, because the majority of associates don't make partners. It's, to me, an anxiety-provoking way of living. And I sort of talk about that in terms of the fact that I wanted to avoid that. And I'm glad I got here, and I was able to avoid that and still get here.
Yes.
And that's a possibility. Think about that. Be more than one-dimensional. Try to, be an interesting person and have a wider net that you reach with in your life. Basically it.
That's about it. Yeah. So any final thoughts before we wrap
my
up?
final thought, Liz, is to commend you on the wonderful job. Don't blush now, because you are in a position where you are sending your law students, who are worthy law students, to federal court judges throughout the country, to help them become federal law clerks. That wasn't always the culture of Cornell. I've been begging in past years that we have a LISPEC, and finally, with our new dean, we got a LISPEC.
He's a wise man.
Yeah, and I've got to end this by telling people how terrific you've been. We have Cornell people now. All Cornell judges are hiring Cornell clerks because you are out there introducing us to them and doing a great, great service to these young people in getting them started in their legal career. So,
well, thank you. That's incredibly kind of you, Judge.
And it's just great to be here to tell you that.
It's delightful to have you back, and I hope you have a wonderful, wonderful weekend, reunion weekend.
Yeah, and we're having a great time right now, and I'm here with my wonderful wife, Betsy, and my colleague from law school, Alan Smith, and his wife, Ruth, who are staring at me from a distance
here in the
right
studio
now.
with us. That's right. We're glad that you all got to join us today. So thank you again, Judge.
Thank you very much.
Pleasure.
It's really been very special for me to be here.
Thank you.
Okay.